Hello everyone, and welcome back to Straight Down the Middle. Here's something I've heard so many times about the Trump verdict. People have said to me, people against the conviction, they say to me, look, Professor, come on. This was obviously a politically motivated prosecution. Bragg said he was going to go after Trump when he was running for office, and he did. Isn't that enough to make it unconstitutional? Well, I want to do an episode on that because it's a very good question. I want to try to walk you through that and give you the arguments on both sides, so let's jump right in. First of all, it's true. District Attorney Bragg, running for office, said over and over that he was going to go after Trump. He said, I'm the best candidate to go after him. He used those terms, go after him. He repeatedly denounced President Trump's policies. He one time said that Trump had embraced white nationalism, and he made it clear that he thought that a Trump presidency would be a danger to the nation. Is that enough to make it unconstitutional? Well, how about this? We add to this that here's something else we know, that once Bragg got into office, we know that he looked for crimes that he could prosecute Trump for. He had his office consider several different crimes. He finally settled on this business records falsification crime, and he went after him, and he got him. Is that enough to make it unconstitutional? Well, it's troubling for sure. Have you ever heard the phrase, show me the man and I'll find you the crime? Well, that was a saying popular in Soviet Russia under Stalin. Supposedly, it's what Stalin's notorious chief of the Secret Service, secret police, said to him. And we do not want that to be the principle of the American criminal justice system. But is it enough to make the prosecution unconstitutional? There's a counter-argument. We could call it the Al Capone argument. Let me tell you what it is. Imagine 100 years ago, some district attorney running for office says, I'm the best candidate to go after Al Capone. My rival candidates, they're afraid they won't do it, or they're in his pocket. Vote for me and I'll go after Al Capone. And then let's say he gets elected to be district attorney. He starts looking for different crimes to prosecute Al Capone, and he finds a tax crime, didn't pay his taxes, and he prosecutes him and he gets him for a tax law violation. Well, most people think there'd be nothing unconstitutional about that. So maybe it's not enough for a prosecutor to say he's going to go after somebody and then go after him. Maybe that's not enough to make a prosecution unconstitutional. But of course, there's a difference. In the Al Capone case, the prosecutor's not going after Al Capone for his political activity or his political viewpoints. And of course, that's what a lot of people think Bragg was doing, going after Trump specifically to derail his candidacy because of opposition to his politics. And if that's what he was doing, well, that is unconstitutional. That's called selective prosecution. You cannot prosecute somebody because you don't like their politics out of hostility to or in retaliation for their political activity. That's just straight up unconstitutional. The problem is, it's difficult to prove. Courts have made that kind of claim especially difficult to prove. So many of us might feel on both sides, Democrats, Republicans, conservative liberals might feel, hey, that's what it feels like Bragg was doing, but the courts have made that kind of claim very hard to prove. Many courts have said there's got to be a comparator. What's a comparator? Well, let me explain what a comparator is. It's got to be a case that's similar. Somebody committed a similar offense, but was of a different political viewpoint or from a different political party, and the state didn't prosecute them. If you've got a comparator like that, then maybe you can make a claim of selective prosecution. Okay, let me give you an example of a comparator like that. This comes out of a case from the District of Columbia not long ago. It's the summer of 2020. A small group of pro-life protesters stage a protest, and as part of their protest, they chalk up a bunch of sidewalks, city sidewalks, with their message, Preborn Lives Matter, or something like that. Preborn Lives Matter. They put it in chalk on a sidewalk and they get arrested. What did they get arrested for? Defacing public property. They're arrested under the District of Columbia's defacement ordinance. And guess what? Under that ordinance, they are probably guilty of defacing public property. But the defendants, they said, hang on a second, just down the street, this is summer of 2020, remember, they said down the street and throughout the city, there are much bigger protests going on, and people are chalking up sidewalks and chalking up streets and buildings with the message, Black Lives Matter. It's happening all over the city, and nobody ever prosecuted them, not one single prosecution for defacement of public property, but you're coming after us, and you're charging us with defacement of public property? And the District of Columbia Circuit, in a decision from just last year, they said, now that's a comparator. With that allegation, if you can prove that, you've just stated a good selective prosecution claim. Now, of course, that's really hard to find. A case, same time, roughly similar kind of crime, roughly similar facts, but from a different political party, different political views. You're almost never going to find that, right? Well, amazingly, there might be a comparator like that in this Trump case. I couldn't believe it when I first read about it, but let me explain it to you. It involves Hillary Clinton. You got to remember the core of the case against Trump. What's the core of the case? Prosecution says Trump falsified business records. How? Well, he took some campaign finance expenses. That's $130,000 in hush money paid to Stormy Daniels. The state says those were campaign expenses, but the Trump organization called them legal expenses. And that was false. That's what the prosecution says. That was false. They were campaign expenses, not legal expenses. And because they were campaign expenses, but not reported as such, that's a campaign finance violation. So that was the heart and remained the heart throughout the case of the prosecution's case against Trump. Now, here's what's so amazing. In 2022, just a couple years ago, the Federal Election Commission determined that the Hillary Clinton campaign had committed a campaign finance violation. What was it? They found that in 2016, the very same year that these events concerning Trump took place, that the Clinton campaign had paid money to fund the Steele dossier. Do you remember the Steele dossier? It was a report containing very scandalous and supposedly incriminating allegations against then-candidate Trump. Well, we didn't know it at the time, but it turns out that the Steele dossier had been funded by the Clinton campaign. And when it was discovered that the Clinton campaign had funded the Steele dossier, the Federal Election Commission started looking, well, how did you report those payments? And it turned out that the Clinton campaign had reported them as legal expenses. That's right, as legal expenses. And the FEC said, those weren't legal expenses. Those were campaign finance expenses. And that violates campaign finance law. You can't call campaign expenses legal expenses without reporting them. Well, that's a surprisingly similar set of facts. But here's the thing. They were never prosecuted by the New York district attorneys. And of course, the Clinton campaign was located, headquartered in New York City. So they could have been. And these facts had all come out by 2022. According to public records, there was never a single prosecution, not of Hillary Clinton, not of anybody associated with her campaign, for falsifying business records to cover up a campaign finance violation, notwithstanding the fact that you got, on the surface of it at least, very similar facts. Now, I don't know all the facts of the Clinton campaign finance violation. I only know what's in the FEC public record. But if we accept that public record for what it is, it sure looks like a very similar case. The Clinton campaign called campaign expenses legal expenses to cover up a campaign finance violation, but was never prosecuted for that by the district attorney in Manhattan. If that's true, well, that might be the kind of comparator that courts demand. That might show selective prosecution. A lot of you have asked me the following question. What's up with the issue of jury unanimity in the Trump hush money conviction? Now, this is a thorny one. I'm going to warn you in advance. This is for people who like to get into the legal weeds, because this issue of jury unanimity is a tough one. Tough one to understand, tough one to get through. But I'm going to walk you through it, and I promise you, I will give you the arguments on both sides, and I hope that once I've done that, you'll understand this issue better. So let's dive right in. Okay, so under the United States Constitution, in every criminal prosecution, the jury has to be unanimous. Now, you might be surprised to hear this, but until just a few years ago, that right, even though it's in the Bill of Rights, only applied in federal prosecutions, not state prosecutions. But as it happens, just a few years ago, the Supreme Court of the United States said, you know what? We've been wrong for 100 years. That right applies in state prosecutions just as much as in federal prosecutions, at least in state felony prosecutions. And of course, that's what the prosecution of former President Trump was, a felony prosecution. So, jury unanimity requirement did apply. And here's what the state's going to say. Where's the problem? The jury was told they had to find unanimously that Trump falsified business records and that he did so to conceal a violation of New York election law. Okay, so what's the problem? There was jury unanimity. They were so instructed. They so found. Where's the problem? Well, the Trump team is going to say, hang on, there's still a big problem. Because that New York election law violation, what did that New York election statute say? It said that it's illegal for two or more people to agree to work in concert to influence an election through unlawful means, that is, by violating some other statute. And Judge Mershon instructed the jury they did not have to be unanimous with respect to those unlawful means. Judge Mershon threw a bunch of theories of what those other statutory violations might be at the jury. He threw three different theories at the jury. At a minimum, he said it could be a tax law violation, could be a campaign finance violation, could be a violation of New York's business records falsification statute, the same statute that Trump was prosecuted under, which introduces a whole other element like a circularity, but put that aside. He said to the jury, you may consider any of those possible theories of a statutory violation, and he didn't say that you can only consider those. He said you may consider those and you don't have to be unanimous. So the Trump team says that's a non-unanimous jury verdict and that's unconstitutional. Now, the state's going to come back and say, no, that's not unconstitutional. Everybody knows that the means by which a defendant commits a crime, how he commits a crime, the jury doesn't have to be unanimous about that. And the state's got some case law on its side because the Supreme Court, in a series of decisions, has held that when it comes to what the court calls the brute facts underlying a crime, the jury doesn't have to be unanimous. What does that mean? I'll give you an example. Let's say defendant's charged with murder. There was an altercation, bunch of people. Defendant is said to have murdered the victim. But 6 of the juries, they think, yeah, we're convinced the defendant murdered the victim, but we think he did it by shooting him. And the other 6 say, no, we don't think he did it by shooting him, but we're convinced that he murdered the victim with a knife. Well, guess what? Under Supreme Court precedent, that's constitutional. 6 could think he did it by gunshot. 6 could think he did it by a knife. No problem. And so the state's going to say, well, this is just the same. It's just like that. The underlying facts, the jury doesn't have to be unanimous about. But the Trump team will come back and say, well, hang on. That's not how it works. The Supreme Court has also told us this, that if the jury is presented with different crimes, not just different underlying facts, but different kinds of crimes. So the jury is told both that the defendant murdered the victim and that the defendant robbed the victim. And 6 jurors think, yeah, we believe he murdered the victim. We don't think he robbed him. And 6 believe, no, we think he robbed him, but we don't think he murdered him. That's not a unanimous jury verdict. You cannot convict on the basis of 6 thinking murder and 6 thinking robbery. Those are 2 different crimes. And if it's 2 different crimes, that's not unanimous. So this Trump people are going to say these different theories of the unlawful means by which they were supposedly trying to influence the election, those are different crimes. You got a tax crime, you got a campaign finance violation, and you've got a business records falsification crime. Those are different crimes. So the judge was inviting non-unanimity with respect to different crimes, therefore unconstitutional. That's what the Trump people will say. But wait, the state has a counter-argument. The state's going to say, not so fast. This was a conspiracy crime. The New York statute, remember, says 2 people or more can't agree to try to influence an election through some illegal conduct. And the state's going to say conspiracy laws are different. They function totally differently. And when it comes to conspiracy laws, you do not have to show unanimity. But the Trump team's going to come back and say, well, actually, you're right, in part, conspiracy laws are different in many ways, but they're not with respect to unanimity. And the Trump team's going to have some cases it can point to, and let me tell you what those cases are. I told you we'd be getting into the legal weeds here, but if you're interested, here's how it works. There's a federal statute. It's called the RICO statute. I'm sure many of you have heard of it. It's the federal racketeering statute. And under the federal RICO statute, one of the crimes you can be charged with is conspiracy. Conspiracy to run an enterprise, a business or something, run an enterprise through a pattern of unlawful acts, through unlawful means. Kind of like the New York election statute, influence an election through unlawful means, RICO, running an enterprise through unlawful means. Well, when it comes to charging conspiracy under RICO, the government has often tried to say, hey, we don't have to convince a unanimous jury of the unlawful acts that the defendants were conspiring to commit. The jury doesn't have to be unanimous. They can, 4 of them can think one crime, 4 of them can think another, it's fine. But the federal courts have said that's not fine. The jury can disagree about the underlying facts, what the Supreme Court calls brute facts, but if the prosecutors are alleging different crimes, so the prosecutors put before the jury the idea or evidence suggesting that defendants conspired to run the enterprise through acts of murder or acts of embezzlement or acts of robbery, federal courts say, no, you cannot have non-unanimity there. The jury has to agree unanimously on the kind of crime that was involved. But here in the Trump prosecution, Judge Mershon specifically instructed the jury in this conspiracy offense that the prosecution could throw before the jury different crimes that the conspiracy was directed toward. The tax crime, the campaign finance offense, or possibly violations of New York's business records falsification statute. And the jury did not have to be unanimous when it came to these different kinds of crimes. So Trump lawyers are going to point to these federal RICO cases and other cases going to say, no, that was unconstitutional. That violated the requirement of a unanimous verdict. Okay, we kind of got into the weeds here. But those are going to be the arguments. They're going to be made on appeal. I hope that this has at least clarified it for you. I will have more episodes answering other questions about the Trump verdict. And feel free to keep shooting me more questions if you like. You've asked me some great questions. You can ask me on YouTube. You can ask me on X. I will do my best to answer them. I might even feature them in another episode. And I'm also going to be doing episodes on major Supreme Court cases as they come down this month. So if that's of interest, I hope you'll tune in. Goodbye and thanks.
Cause the flag still stands for freedom, and they can't take that